Hi everyone, I'm April Train Cesario, first year hospitality management student. Today I'll be sharing some insights from reading in Philippine history.
Go.
So our topic for today is about Agrarian law. So magsiling ta Agrarian law, sila ni ang mga farmers nga wala duta nga um, hindi lang inibahin sa nagapanagtagduta, kundi lakit man ang paghatag sa mga serbisyo kag suporta sa mga huma para mag-angat ang ilang kabuhi. So, Republic Act number 6,657, also known as the Comprehensive Agrarian Reform Law of 1998. So, amo na siya ang law nga nagabulit sa mga mga farmers nga wala sa duta para magmayo ilang ang kabuhi. So, ang layo nga ini nagahatag oportunidad man sa magpatiida na mangunguma sa ilang pangabuhian kag pagis ini ginahandom nga mag-angat ilang ekonomiya. So, agrarian reform means redistribution of lands, regardless of crops or fruits produced. The farmers and regular farm workers who are landless, respective of tenurial arrangement, to include the totality of factors and all others designed to lift the economic status of the beneficiaries and all other arrangements alternative to the physical distribution of lands. So, agrarian is derived from the Latin word ager, which means a field. Lexically, the word agrarian means relating to the land or to the ownership or division of land. So, ang meaning ko na sa agrarian is pause na lang.
Wait lang. 1, 2, 3.
Agrarian reform policies. Pre-Spanish era. So, magsiling ta pre-Spanish era, ang mga panahon nga wala pa mga Kastila. So, this land is ours. God gave this land to us. Ang mga time, ang duta, so nasa wala pa mga Kastila, ang duta, nagpapanag-iyan na sa mga tao sa komunidad. So, wala nila ang time bisa ka Kastila. So, private ownership is unknown to almost all of the people sojourning in the Philippines, and a system of communal ownership is enjoyed by many in terms of land ownership. Spanish period. The discovery of Magellan leading to the expedition of Miguel Lopez de Legazpi. So, sa pag-abot sa mga Kastila, so balik dito kung sa encomienda system na nagahatag tagahon sa mga Kastila sa duta kag pagkuha sa buhis nga nagadala sa pag-abuso sa mga luman. Gintuga man ang hacienda system sa 19th century diin mga mayaman kag Kastila na nagapanag-iya sang malapad nga duta kag ang mga mangunguman nalipatan kag wala sa mga duta. So the encomienda system was an unfair and abusive system as compressed vandalas. From the encomienda system, the hacienda system was developed in the beginning of the 19th century. The different changes brought about by the encomienda system gave rise to the issuance of two royal decrees merging landowners to secure legal title to their land, and the moral law that granted landholders 1 year to secure legal title to their land, or the same will be forfeited.
Good morning, Miss. Good morning, everyone. I'm Miguel Haganos from BSHM 1B. Spanish period land situation, land tenancy under Spain, ecomedial system, rise of cacique class, early rebellions, conflicts over lands, prior lands, Philippine Revolution. Philippine Revolution government, 1898 to 1899. The establishment of the Philippine Republic by Emilio Aguinaldo is coupled with his intention of confiscating large estate granted to friars. This controversy led to what is now known today as 1898 Philippine Revolution. So, sa ang pagtatag ng Republika ng Pilipinas ni Emilio Aguinaldo ay ang nag-uugnay sa kanyang layunin na kumpiskahin ang mga dagko nga mga duta or ari-arian na ipinagkaloob sa mga praile. American Rule, 1898 to 1935. Long live America. The seizing of power of the Spanish government led to the colonial rule of the Americans by the virtue of the Treaty of Paris. Amo naman ni siya ang sang naungtat ang pagkapyat sa mga Espanyol sa aton. Sang naluwas kita sa mga Espanyol, diri take advantage sa mga Amerikano para sakupon kita kag sila naman ang mamahala sa Pilipinas. Policies implemented by the Philippine Commission. Philippine Bill of 1902 provided regulation on the disposal of public lands. Private individual may own 16 hectares while a corporate landholders may own 1,024 hectares. Amo naman na siya ang naghahatag rule kung sa diin ang isa ka tawo pwede makatag-iya sang 16 hectares kag ang isa ka korporasyon naman niya is 1,024 hectares. And Act number 496, also known as the Land Registration Act, which introduced the torrent system of the land registration, was introduced to solve the matter. Ang ari is amo ni siya ang arang makaparehistro sila sang ilang duta nga ginatawag nila nga tourist system. Kag Homestead Program 1903, allowing a tenant to enter into a agricultural business by acquiring a farm at least 16 hectares, limited only to northern Luzon and Mindanao, where colonial penetration had been difficult. Amo naman ni sa mga pwede kapa-arikila duta, kag pwede maka-arikila duta, pero waay dapat ginubo sa 16 hectares. Kag limitado lang ni sa Hilagang Luzon at Mindanao kung saan may hirap ang pagpasok ng mga kolonyal.
Bright morning and mabuhay. My name is RBF Agrarian from BSHM 1B. So today, I'm going to discuss about the Commonwealth era in 1935-1946 government for the Filipinos. With the setup of this era came the implementation of the Rice Tenancy Act of 1933. Primarily, this act regulates shared tenancy contracts by establishing minimum standards. Accordingly, a better land-for relationship is envisioned, having a 50-50 sharing of the crop. Regulation of interest to 10% per agricultural year, and particularly a safeguard against the whims and caprice of the landlord. However, since the implementation of the Act requires a petition of the majority of the municipal councils, no petition was ever made. Due to these minor lapses to its implementation, President Manuel Quezon made its implementation mandatory in all Central Luzon provinces. However, contracts were made to last only for a year and landowners were able to endlessly dismiss tenants by the simple act of not renewing their contracts. So wala nila kung gina-renew ilang mga kontrata. So hence this created more agitation on the part of peasants organization doing their obligation well but were still dismissed despite their great service to till the soil. His administration created also the National Rice and Corn Corporation to assign public defenders to assist peasants in court battles for their rights to the land. And the homestead program is also continued through the National Settlement Administration, or also known as NLSA. Second, Philippine Republic or Japanese occupation in 1941-1945, the era of Hukbo Lahap. The Hukbo ng Bayan laban sa Hapon, Hukbo Lahap, was born under the Japanese occupation. So, ang Hukbo Halap daw is under na siya sa mga Japanese na mga ginaubra. It was headed by Luis Tarok. Siya ni ang lead sa mga Japanese occupation. Was able to take advantage the social unrest after the World War II. They were able to establish a shadow government in Central Luzon that discredited the government in the eyesight of the people. These consequently made them stronger and closer to the people. So, ang ari ko ang Japanese occupation is tugahim although isa ni sa way nga para mag stronger kag close ang mga tao nga mga Japanese sa
Good day! I am Rachel Almanlanat and I am the one who assigned to report this part. Ang ilaha ko ng main goals ay pabilisin ang programa ng resettlement para malipat ko ang mga magsasaka sa mga small nga population like Mindanao or Mindanao. Quirino administration in 1948 to 1953 with the announcement of these two main objectives, that is economic reconstruction of the nation and restoration of the faith and confidence of the people in the government. None of it speaks of the making of agrarian reform law. He created the Land Settlement Development Corporation or LASIDECO to accelerate and expand the resettlement program for peasants. Administration 1953 to 1957. He introduced two land bills, that is the Agricultural Tenancy Act of 1954 and the Land Reform Act of 1955. The former act shifts the tenancy to leasehold. In the leasehold system, the tenant is paying a fixed amount to the landlord rather than a variable amount. This consequently gave to the prohibition of ejecting tenants without further pronouncement of the Court of Agrarian Relations as to the existence of this cause. It allowed also for the division of crops into land, labor, animals, implements, final harrowing, and transplanting. Land Reform Act of 1955 provided for the expropriation of private agricultural land over 300 hectares of contiguous areas, if owned by individuals. The passage describes the land reform initiatives introduced by President Ramon Magsaysay during his administration in 1953 to 1957, aimed at addressing issues of agricultural tenancy and land ownership in the Philippines. In summary, these laws were intended to improve the conditions for tenants, farmers by regulating the terms of land use, securing tenant rights, and promoting fairer land distribution through expropriation of large estates. So, it means na inlipat daw ng batas na ito ang sistema mula sa sure tenancy tungo sa leasehold tenancy, which is ang Agricultural Tenancy Act of 1954 to 1957. Pinoprotektahan din ng batas ang mga nangungupahan sa pamamagitan ng pagbabawal sa pag-aalis sa kanila maliban if may permission sila sa Court of Agrarian Relations. Third to fifth Philippine Republic Rojas Administration in 1946 to 1948. He proclaimed Rice Tenancy Act of 1933 effective all over the country. However, land tenure was still noted as a problem and was noted to become worse despite numerous remedial measures. Among these measures was Republic Act 34 of 1946, otherwise known as Tenant Act. This provided for a 70 to 30 sharing arrangement and further regulated share tenancy agreements. So, ang Rice Tenancy Act of 1933, which was made effective nationwide by President Manuel Rojas during his administration in 1946 to 1948, was aimed at addressing the problems of land tenancy in the Philippines. The act was intended to improve the situation for tenant farmers, particularly in terms of the share they received from the crops they worked. So, ang Republic Act 34 of 1946 kuno na kilala rin bilang Tenant Act o isa lang na sila. Ang batas na ito ay naglalayong ayusin ang ugnayan sa pagitan ng mga Panginoong may lupa at mga mangungupahan na magsasaka sa pamamagitan ng pagpapakilala ng 70 to 30 na pagsasaayos ng pagbabahagi kung saan ang mga nangungupahan na magsasaka ay tatanggap ng 70% ng ani at ang may-ari ng lupa ay tatanggap ng 30%.
Hello everyone, I'm Genders Feliciano. I'm a BSHM student. This is my topic. Sigrasya Administration 1957-1961. Wala siya naghimo sang aksyon o deklarasyon bahin sa agrarian reform. Tungod sini wala natabo nga pag-uswag sa tunga sang landlord kag ila mga aliado. Si Makapagal Administration 1961-1965. Iya ginpatuman ang Agricultural Land Reform Code of 1963, Republic Act 3844. Ini nga balaod, tuyo iya nga baklon ang private farmlands kag ipanagtag sa mga wala duta nga tenants sa madali lang nga pamaagi sang pagbayad. Sa panahon ni Marcos, nagtagumpay siya sa mga programa para sa pagbakal kag pagpanagtag sa mga duta. Kaginlunsar ang Tenant Emancipation Act para sa hatagan ang mga mangunguma sang ila kaugalingon nga duta. Pag-abot kay Aquino, iya ginporsige nga agrarian reform, pagpanagtag sang duta ang pinakaimportante nga programa sang gobyerno para buligan ang mga Pilipino kag palambuon ang ila kabuhi. Si Aquino ginhimo sang sentro sang iya gobyerno ang agrarian reform kag nag-issue sang Comprehensive Agrarian Reform Law, Republic Act 6657 nga naghatag duta sa mga mangunguma. Sa panahon ni Ramos ginpasanyogya ang pagtuman sini nga programa pero naglisod sila kay kulang ang pundo para sa maayos nga implementasyon. Sa Estrada Administration 1998-2001, insuguran ang programa nga magsasaka agud makaengganyo usang foreign investment sa agrikultura kag mauswag ang teknolohiya sa crop production. Pero ang problema sa agrarian reform wala gyapon nasolusyonan. Sa Arroyo Administration naman 2001-2010, pinirmahan sa siyang Carper Comprehensive Agrarian Reform Program Extension with Reform to Republic Act 9700 nga ginkombinar ang Senate Bill 2666 kag House Bill is 4077 agud ipadayon kag pasanyagon ang Agrarian Reform Program.
Good day everyone, my name is Jeremy Magsumbol. Today I will discuss about land reform. Land reform is a more popular term used by students but its concept is limited compared to agrarian reform. So ang land reform law guys ay tumutukoy sa pagbabago at pagmamayari at paggamit ng lupa upang matugunan ang mga issues na pagkakawala ng lupa, pagkakawala ng tirahan at kahirapan. Nakatuon sa pagmamahagi ng lupa mula sa malaking may-ari ng lupa patungo sa maliit na pagsasaka o komunidad. Ang layunin nito ay mabawasan ang kawalan ng pagkakapantay-pantay at kahirapan ng mga rural na lugar. So dito naman tayo sa agrarian reform. Agrarian reform is a refers a term which comprises not only land reform but also the reform and development of complementary institutional frameworks, rural education and social welfare institution not limited simply to the question of the relation of the farmer to the land.
3.
So, ang agrarian reform ay isang malawak na konsepto na sumasaklaw sa pagbabago ng patakaran, institusyon at mga gawain sa sektor ng agrikultura. Nakatuon sa pagpapabuti ng kabuhayan ng mga magsasaka at komunidad sa kanayunuan sa pamamagitan ng pagpapalawak ng kanilang karapatan sa lupa at pag-access sa mga serbisyo at pinansyal na suporta. Ang layunin nito ay mapabuti ang produksyon ng pagkain, seguridad sa pagkain at kabuhayan ng mga magsasaka.
3.
The Agrarian Reform Group Program. It is designed to bring about improvement in all the institutions surrounding farm life and other group measures necessary to make the work of the tenant, farmer, and owner cultivator a success. So, ang ginapaminti sa Agrarian Reform Program, gidesign siya para mag-improve ang mga institutions surrounding para sa pangabuhi sa ga-farm o maging successful ang gaobra. Objective of the Agrarian Reform Program. The Agrarian Reform Program is an integrated plan of action that aims to solve the problem of low agricultural productivity and profitability to our farmers. The primary purpose of aim to the program is to transfer land ownership from the landlord to the tillers of the soil in order to achieve the dignified existence for small farmers. So ang goals sa objective of Agrarian Reform Program is gahimo slag action or plano para masolbad ang problema sa mga low agricultural productivity para sa mga pigado nga farmers. The importance of Agrarian Reform Program. Number 1. The importance of Agrarian Reform Program cannot be overemphasized because this is the basic step for government to make measure to improve the living condition of the farmers who are directly related to the land use. Number 2, it makes the farmers independent land ownership sitting them free from the bunch of soil and farm poverty and debts, making them productive participation nation building. Number 3, it helps the farmers secure capital investment for a new industry. Number 4, the program hopes to correct the imbalance of society by readjusting social structure of farm. Laboratories and wage earners are the sellers of public land and farmers owning the family-sized farmlands. Number 5, it also paves the way for the creation of stable stable society that will make more accurate, more meaningful.
Nature of concentration serves as a supreme of fundamental law established base framework and underlying principles the government decide to protect the base right of the people. Ang konstitusyon ay disenyo upang protektahan ang mga pangunahing karapatan at kalayaan ng mga tao, madalas sa pamamagitan ng isang Bill of Rights, mga tiyak na probisyon. This ensured that government operated with a set boundaries, citizens are protected from potential abuse of power. Ang konstitusyon ang pinakamataas na batas ng isang bansa. Nangangahulugan ito na anumang batas o aksyon na ginagawa ng pamahalaan ay dapat sumusunod sa mga probisyon nito. Types of constitution: righted or unrighted. Righted constitution, one whose receipt of are embodied in one documents or set of documents. Unrighted constitution concept as rules which have not been integrated into a single concrete form but are separated in various sources, such as letters of a confidential character, judicial decision, commentaries of published custom and traditional and certain common law principles. Writing constitution is a formal document that lays out the fundamental law and principles of country. It's like a rule book for how the government should operate. Unwritten constitution is not contained in a single or formal document. Instead, it is derived from multiple sources as a status, judicial decision, custom of tradition, and common law and principles. Example include the United Kingdom Constitution, which is based on various acts, country rules, and long-standing tradition. Constitutional enacted by commonality involved. Conditional constitution, one is the formally track of a defined demand place following unconscious or deliberate effort taken by constitution body of rule. Cumulative constitution is the result of political evolution not integrated in a specific time, but changing by action rather by the any systematic code. Conventional, there's a formal, deliberate effort to establish the constitution. A specific body is tasked with the drafting and adopting it often. After significant political change, revolution, this constitution formed. Gradually without formal founding moments, it's evolved through history, adapting new circumstances and more flexible as it changed in response of societal needs. Illegal development without formal amendment process, making it more adaptable change circumstance. Rigid constitution can help prevent has the population decision that may undermine essential rights or governance. Structure. Flexible constitution focus on adaptability, allowing illegal frameworks to evolve and society change. Rigid or flexible. Rigid constitution is one can be amended only by formal and usually difficult process. Flexible constitution is one can be changed by ordinary legislation as the case of unwritten constitution. Rigid constitution can help prevent has the population decision that may undermine essential rights or governance. Structure. Flexible constitution focus on adaptability, allowing illegal farm works to involve in society change.
Ang Constitution of Sovereignty, ano siya ang constitution nga nagapatungod sa mga provision nga nagasaysay kung paano mahimo ang mga formal ng pagbag-o sa fundamental. For example, hindi man kayo detalye, pero bastante ang sulod ng second malapad nagalakip sa bugos na estado kag mga na katungod sang mga pumuluyo, lakip na ang mga posible nga kahimtangan sa palabuton. Kag ikatatlo, klaro ang mga kahulugan kag interpretasyon nga dapat klaro kag hindi malibog or dapat klaro gid siya. So ang amo ni nga konsepto importante sa pagtuman sa demokrasya kag pagsiguro nga ang mga balaod nagaserbisyo sa tanan ng mga pumuluyo sa insakto. Evolution of Philippine Constitution 1897 nabiak na Bato Constitution. This constitution was a provisionary constitution of the Philippine Republic during the Philippine Revolution and was promulgated by the Philippine Revolutionary Government on November 1, 1897. So, bali, ang biak na Bato Constitution isa ka importante nga bahin sa kasaysayan sa Pilipinas because yun pakita niya ni ang una nga pagtuad sa mga Pilipino sa paghimo sa ilang nga own nga governo samtang nag-aaway sila batok sa mga Kastila or nag-aaway sila sa mga Kastila kag ini nga nagatudlo nga ang mga Pilipino hindi lang mga revolusyonaryo kundi mga tawo nga may abilidad magporma sa kaugalingong sistema sa gobyerno ng regardless kung matabo sa ila tungod bisan pa sa katunga sa kaaway so baligin fight kid nila para sila nga para makamit nila ang ilang independence. So ang biyak na bato ginbase sa Cuban nga constitution nga nagpakita nga bisan ang mga revolutionary or revolutionaryo sang iban nga pungsod naka-impluwensya sa aton. Ang pagkopya nila sa Cuban nga modelo nagapakita sa ilang nga pagtuo nga ang ilang freedom or kalayaan maabot kung sundon ang ehemplo sa iban nga nasarangan na ang mga manunulat nga sanday Isabelo Artacho kag Felix Ferrer nagsulat sini nga Espanyol naga-inspirar nga ng inisyatibo ang mga leader sang revolusyonaryo nga nagtukod sang instructura na makapaandar sa gobyerno. So ang ini nga constitution bisan wala pa gid siya na-approve naga tulagway sang handon sa mga Pilipino nga magbaton sang independence or magkamit sang independence kag maghimo sang gobyerno nga may tahom sa tanan. Ang paggamit nila sang Tagalog hindi lang Espanyol isa ka indikasyon nga may intensyon silang mupokus ang nasyonalismo sa common na tao hindi lang sa elitista. Malolos Constitution. This is considered the first constitution in Asia written by people's representative in the 1993 Constitution. Headings McDuffie Law provide authority to the Constitutional Conventional headed by Claro M. Recto to craft a constitution. So, Malolos Constitution 1899. Ang Malolos Constitution ano sa pinakauna nga constitution sang Asya nga nagsulat sang people's representatives. So nagpakita ini sang abilidad sang mga Pilipino sa pag organize ang ilang republikang gobyerno pagkatapos pag paghimakas batok sa mga Espanyol or pagkatapos ang ilang awas ng Espanyol bisan wala ni nagdugay tungod sa ang pag-occupy sa mga American sa aton during that time. So sini nga simbolo sa aton nga handom sa independence. So in 1935 Constitution ginhimo bilang preparation para sa aton nga kalayaan or freedom. So base kay tidings McDuffie ang kag si Claro M. Recto nga nangunaha sa Constitutional Convention. Ini nga constitution nag-establish sang modernong gobyerno sa Pilipinas. So naghatag ni focus sa democracy kag tungod sa mga tawo man. The 1973 Constitution, the Philippine Congress called the Constitutional Convention to change it. In 1935 Constitution headed by Carlos P. Garcia, but unfortunately he died and Diosdado Macapagal replaced him. Before the convention finished the Constitution, the martial was declared on November 29, 1972. The convention approved its proposed constitution. So the 1973 constitution ginhimo para maislan ang 1935 na constitution. So si Diosdado Macapagal ang naging leader sa amo nga constitution convention. So pagkatapos na pati si Carlos P. Garcia bisan wala pa natapos gin-declare ni Marcos ang martial law kag sa November 29, 1972 na-approve ang bag-o nga constitution nga nagpalapos sa powers ng atong nga presidente.
Effectivity of the Constitution. The present Philippines Constitution took effect on February 2, 1987, which is the date of its ratification in the plebiscite held on that same date, not on the date its ratification was proclaimed. Amendments and revision refers to a change that adds, reduces, or deletes without altering the basic principles involved. Generally affects only the specific provision. So, ang pag-epekto sa konstitusyon, ang presentang konstitusyon sa Pilipinas nag-umpisa ini sa pag-epekto sa February 2, 1987 nga among petsa sang iya pag-ratify sa plebisito nga patigayon sa among nga petsa kag hindi sa petsa nga ginpahayag ang iya pag-ratify. So, ang konstitusyon nagluntad kag nag-umpisa nga ipatuman matapos nga gindeklarar sa mga tawo sa plebisito sa Pebrero 2, 1987 nga amo ini ang ila sundon nga konstitusyon. The Freedom Constitution. It took place by virtue of Proclamation No. 3 of President Corazon Aquino. This is a transitional constitution while a constitutional commission drafted permanent constitution, the 1987 Constitution. The Constitutional Convention headed by Cecilia Munoz Palma was composed of 48 members to draft a permanent constitution. This was adopted on February 2, 1987. Ang Freedom Constitution natabo ini paagi sa Proclamation No. 3 kuno President Corazon Aquino. Ini ang temporaryo nga konstitusyon samtang ang Constitutional Commission nagahimo sang permanente nga konstitusyon. So, ang Freedom Constitution kuno isa ka panandali nga balaod nga ginpatuman ni President Aquino matapos ang People Power Revolution. Ginahulat nila nga matapos ang permanente nga constitution. Ang 1987 Constitution naman niya, ang Constitutional Convention, ginpamuno ni Cecilia Munoz Palma kaginlain ang 48 ka miyembro para mag-draft sang permanente nga constitution. Ini gindawat sa Pebrero 2, 1987. So, ang permanente nga constitution nga ginhimo matapos ang transitional nga Freedom Constitution. kagindawat na ini bilang opisyal nga balaod sa Pilipinas sang 1987. Feature of 1987 Constitution. The new Constitution consists of 18 articles and is excessively long compared to the 1935 and 1973 Constitution. Purpose of the Constitution: to prescribe the permanent framework of a system of government, to assign to the several departments their respective powers and duties, and to establish certain first principles on which the government is founded. So mga features ng 1987 Constitution. Ang bag-o nga Constitution ma-18 ka article, kag ini sobra ang kalawig kumpara sa Constitution sa 1935 kag 1973. So ang 1987 Constitution mas lawig kag mas detalyado kumpara sa mga nagligad nga Constitution. Naghimo sang mas klaro nga mga balaod kag patakaran. Katuyuan sa Constitution. Ang katuyuan sa Constitution amo ang paghatag sang permanente nga balangkas sa sistema sang gobyerno, pagbahin sa mga poder kag mga katungdanan sang tagsa kag departamento, kag pagtukod sa mga una nga prinsipyo nga ginpanindugan sang gobyerno.
Two tests to determine whether the proposal is revision or amendment. Quantitative test and qualitative test. Quantitative test is asked whether the proposed change is so extensive in its provisions as to change directly the substance entirety of the Constitution by the deletion or alteration of numerous provisions. Qualitative test asks whether change will accomplish such far-reaching changes the nature of our basic governmental plan as to amount to a revision, whether is an alteration in the structure of government is a proper subject effiquely. Steps in the amendment or revision of the Constitution. Proposal. Article 17, Section 1, 1987 Constitution. Proposal. The process begins with a proposal to amend or revise the Constitution. This can be initiated by Congress, Constitutional Convention, People's Initiative, submission, and ratification. Congress. Both the House of Representatives and the Senate must pass a resolution proposing the amendment or revision by a 3/4 vote of all their members. Constitutional Convention. A constitutional convention called by the Congress upon a 2/3 vote of all its members can propose amendments or revisions. People's Initiative. A petition signed by at least 10% of the registered voters can trigger a constitutional convention to propose amendments or revisions. Submissions. Once a proposal is approved, it is submitted to the electorate for ratification. The proposed amendment or revision must be ratified by a majority of the votes cast in national referendum. Referendum is the power of the electorate to approve or reject legislation through an election called for that purpose. Referendum may be on statutes and local laws.
Date of effectivity of the amendment or revision. The date of effectivity of the amendment or revision shall be the same day as that of the ratification, the day on which the votes are cast. However, the amendments themselves might specifically otherwise. Judicial review or proposals. Judicial review refers to the power of the courts to test the validity of governmental acts in the light of their conformity with a higher norm like the Constitution. Unang bahin, nagasiling nga ang bisa sang pag-amyenda o kon pag-usmod magsugod sa amo nga adlaw nga ginakubahan ini. Kundi, pwede man nga may lain nga petsa kung gin-specified sa pag-amyenda. Ang ikaduha naman nga bahin, ang judicial review naghahambal nga ini ang gahom sang tukmanan nga usisaon kun ang mga aksyon sa gobyerno nagasunod sa konstitusyon o kun mas mataas nga balaod.